Welcome. Thanks for joining today's webinar. My name's Ranald McTaggart. I'm Head of Practice Development at the CYCJ, and we're delighted to host this webinar today. So thanks for joining us. This is the first in a series of webinars that we'll be delivering to support the implementation of the Children's Care and Justice Act, which was passed by the Scottish Parliament in April and received royal assent in June. The Act represents a really significant step in the journey towards ensuring that the rights of children in conflict with the law are upheld. The provisions in the Act are commencing gradually, with the Scottish Government currently working on a timeline for commencement. The CYCJ has published a general info sheet on the whole Act on our website, as well as an info sheet specifically on today's topic of ending the use of YOI. And Sally's going to add links to those two into the chat. The aim of today is to get you thinking through the practical implications of the Act for your organisation, and building on this, the CYCJ is really keen to discuss how we can support you and your organisation to prepare for implementation of the Act. So please get in touch if there's anything else we can do to support you with that. If you're not already signed up to the CYCJ mailing list, please do so, and we'll put a link in the chat for that as well. And the same webinar is going to be run again on the 12th of September. Today's webinar will be for an hour maximum. There's a lot of attendees, so your camera and mic will be switched off, and we'll be recording the webinar and publishing that on the CYCJ website. So after the presentation, we'll have up to maybe 30 minutes for Q&A. So given that you can't ask the questions using your camera or your mic, please type your questions into chat box. So you can do that at any time. So as the presentation is going along, if something pops into your head, just type it in, and we'll do our best to get through as many questions as we can in the Q&A time. If we run out of time, then we'll take a note of any questions that haven't been answered, and we'll collate all these and add them to the info sheet Q&A, and a revised version of the info sheet will get published after the second webinar. So we're delighted to have two speakers today who were both heavily involved in the successful passage of the Act. Liz Murdoch is the Youth Justice and Secure Accommodation Team Leader with the Scottish Government, and Debbie Nolan works for the CYCJ and has recently returned from being seconded to the Bill team. So I'll hand over to Debbie, who will take us through the first few slides. Thanks, Debbie.
Great stuff. Thanks, Ranald, and great to see so many people joining us today. So just quickly, before we kind of get into the substance today, just really want to set out what the aims of this session are. So it is really to raise awareness of the ending of young offenders institutions for children in Scotland under the age of 18, to highlight the legislative provisions in Children Care and Justice Scotland Act that will enable that change to take place, to outline the preparations that have been undertaken for that change, and to explore some of the practical implications, practice implications for children who are remanded or sentenced before moving into our Q&A. So I'm sure most people will be very familiar with the case for change, but really just to clarify that the promise were crystal clear that young offenders institutions are not appropriate places for children and only serve to perpetuate the pain that many of them have experienced. It was really fundamental that the promise made gave that such clarity of that. But they also clarified that there will be times where it's right to have children's liberty restricted or indeed deprived, but that must only be done when other options have been fully explored. So that is consistent with UNCRC and Article 37 of the UNCRC, that deprivation of liberty, alternatives to deprivation of liberty should always be explored. And in CYCJ have recently published a practice guide chapter on that, which might be helpful to people. So therefore, where children do need to be deprived of their liberty, it should be for the short space of time, small, secure, safe, trauma-informed environments that uphold the totality of children's rights. So this was the conclusions reached in the promise in 2020. The Scottish Government accepted that conclusion, and I suppose almost ran with that recommendation that the use of young offenders institutions for children would end, and that it would end by this calendar year. So there's the case for change from the promise, but really this change is rooted in evidence as well. So children in secure care in YOIs, what the research has identified is that these children have very similar needs and experiences. And CYCJ research was undertaken last year, really looking at the needs and experiences of those cohorts of children. And what they found was that whether children were in secure care or YOI, they had high levels of experiences of adversity. They often had significant needs, and actually were often the same children. So had either been in secure care and now were in YOI, or were in YOIs and had previously been in secure care. So really found that these were often the same children, and that in both cohorts of children had demonstrated and often resulted in acts of significant harm having been undertaken. So really similar needs and experiences. And then secondly, what we know is that secure care centres are already caring for these children. So the integrated model of secure care has been long-standing, whereby children are not separated based on their needs and deeds. Children who are placed through a justice route or are placed through a children's hearings route are cared for in the same secure care settings. And where children have caused, I suppose, the most significant harm or the gravest harm, these children are cared for in one setting. And centres are already caring for these children together. What we know is from the social work, children and family statistics from last year, what we also know is that children, over 40% of children by age 16 plus, secure care centres are already caring for older children. And in addition to that, we know that children who have been sentenced and remanded are also already being cared for in secure care settings. So last year, or 2021-2022, for example, 8 children had been placed in secure care on remand, and there had also been sentenced children, but those figures are not frequently reported given the low numbers of children and risk of identification. So really what the research there found was that these are similar children, similar needs. Secure care centres are already caring for these children, but also from English research which looked at the routes for children who come into secure care and the offences that they had committed and types of offences. And actually what that found was that there was no greater risk to other children or staff dependent on the placement route, or indeed the gravity of the offence that had led to the child being placed in secure care. And then finally, we have our data. So our data tells us that these children are already being cared for. Our data also tells us how many children have been in YOIs. So last year there was a daily average of 9 children in YOIs. And yesterday and today there's 6 children in YOIs. So that's what the evidence already tells us. So we had this clear mandate from the promise. There was also the evidence that supported this change coming. So the Children Care and Justice Scotland Act, provides the legislative vehicle for allowing this change to take place. So how does the Act do that then? Well, the Act will treat all under 18s as children, and this will be through the children's hearings in legislation and also criminal justice legislation, although at the current time the provisions of that are only relevant to children who are remanded or sentenced. What that will do is it will remove this anomaly whereby not all 16, 17-year-olds have a route to secure care when they require that. So the Act will change that and will allow 16, 17-year-olds who have been sentenced or remanded to be placed in secure care, giving all of those children a legal route. So when children are now remanded, they will still be remanded to the care of the local authority, and that will either be a court requirement that the child is then placed in secure care, or it will give the local authority discretion to determine an appropriate place of safety for the child. There will no longer be the ability to remand children to YY. So that will be the only 2 routes available. If the court says that a child has to be remanded to secure care, as at the moment, the child has to be remanded to secure care. The local authority does not have discretion on that. But if the child is remanded to the care of the local authority can decide And if the child was to be placed in secure care, the secure care regulations would need to be met. In terms of sentenced children, so at the moment children could be sentenced to secure care or a YOI. Sentenced to YOI will end and children can be sentenced to secure care only. If it is solemn cases, it will only be secure care. And that would be where Scottish ministers would direct where the child could go. So if a child's sentenced under solemn, that is, Scottish ministers will decide, but that could no longer be a YOI. And children could also still be sentenced under summary proceedings, in which case the child would be sentenced and again placed in the care of the local authority to determine the appropriate place of safety. And that could be secure care if the corresponding secure care regulations are met, but it could be other placement types as well. So for the ones where there is discretion on the local authority, there's clear roles and responsibilities, particularly for the Chief Social Work Officer and Head of Unit, for the Chief Social Work Officer to consult with certain people to make sure that placement in secure care would be in the child's best interest, that that placement would be appropriate to the child's needs, and that the secure care criteria will be met. And in due course, under the Act, the secure care criteria will be updated, but that hasn't happened yet. That will follow. So with that change then, a corresponding definitional change is made, which means that the term young offender or the term young offenders institutions will now only apply for children aged 18 and people aged 18 or over. And that will cement the inability for under 18s to be placed in YOIs. There's also the removal of legislative reference to remand centres because there is none in Scotland. And there will also be a legal duty on local authorities, which already happens in practice, to provide and maintain residential establishments for children who require criminal justice placements. And the final change that is made is that children are to be treated who have been remanded or sentenced and placed in secure care for any length of time need to be treated as if they were a looked after child. And what that will mean will be that those children have there's corporate parenting responsibilities to those children for the duration of them being looked after. But in addition to that, those children will potentially have access to aftercare entitlements. And the briefing paper that Sally has shared has a lot more information on that and links to other information. And as I said, the regulations will be updated in due course, as well the secure care criteria, as well the provisions in the Act that could allow children to remain in secure care beyond their 18th birthday to a maximum age of 19. And these particular provisions in the Act will commence no later than the week beginning the 2nd of September, so imminently. So that's what the Act does, and I'm just going to hand over to Liz, who can walk us through what some of the preparatory work has been undertaken to support the enactment of those legislative changes. So Liz.
Thanks, Debbie. As Debbie's just said, the regulations were actually laid in Parliament last Thursday and will come into force next week, and also include transition arrangements for children currently in Parliament YOI. So a lot of preparatory work has been undertaken already in advance of that. The Act received royal assent on the 4th of June, so pretty much from that date is where it's the work's ramped up to ensure that those provisions are in place for no under 18s in YOI. As Debbie's mentioned, we've also CYCJ also carried out a lot of research and during the bill process that looks into the needs of children in secure and in YOI. And we've also received information from the secure centres and also SBS as well around the care that they provide for children, and some of the changes I suppose that potentially might have been needed in place for this part of the Act to come in to force. Leading up to over the last year and a half, the Scottish Government have also been funding 16 beds and 16 places in secure accommodation, so that's 4 beds in each of the 4 centres, and as soon as a bed becomes available, we'll pay for that bed until it's needed by a local authority or ourselves for Scottish Ministers' responsibility placement. So the purpose of that funding is to bolster financial stability to the secure centres, but also kind of to ensure ongoing capacity, because we are aware that obviously in the past there have been kind of times where secure has been pretty full, and that there has been that kind of previous reliance on cross-border placements, so placements predominantly from England or Wales. And that's not to say that those placements can't still exist. There will obviously still required to be placements, but only if it's in the best interest of that child to be placed in Scotland. So that will kind of continue. The engagement that we've had pretty much over the last kind of couple of months has been with fortnightly meetings with the secure providers, the Scottish Prison Service, Care Inspectorate, Social Work Scotland and Education Scotland, and Children and Young People Centre for Justice as well. And that's to start those discussions around the safe transition of children, and to also kind of highlight and discuss any kind of concerns around when the provisions come in, and trying to address those at an early stage. Obviously, it's difficult to preempt everything that might crop up, but we've obviously had those planning discussions to try and obviously preempt some of those issues and concerns. We've also had engagement with the Judicial Institute, and also with regular meetings with the Crown Office and Scottish Courts and Tribunal Service around the changes, and those discussions have been kind of fruitful. We are aware that obviously children up until next week can be placed still in Parliament, and obviously that is down to the independence of the judiciary, and we can't influence that in any shape or form, and we wouldn't want to. But I know information has kind of been circulated to the Judicial Institute, which will hopefully kind of advise on, explain these changes, and highlight that obviously children will be transitioning from the 28th onwards. So those discussions are ongoing with the secure centres and with Scottish Prison Service, and the transition regulations also include the flexibility for children to move from commencement up until the start of September. So giving a short window, a period of time for allowing kind of movement and safe placement of children into secure who are currently in Parliament YOI. The children who are placed in Parliament at the moment will, as Debbie has outlined, kind of the legislative change will still be the responsibility of the local authority or ourselves if it's a sentenced child. And one of the key things, I suppose, that has come up recently is about children appearing in court and notification for local authorities to be aware that child's in court, so that preparations and planning can be in place for those children to be receive a suitable secure placement to be found if appropriate. Obviously, while thinking about alternatives to secure as well, and obviously alternatives to remand where possible, as usual practice would be. So just in respect of remand placements, just to confirm that I know it's been a kind of ongoing kind of ask for a number of years, I suppose, but given the burden that the Act places on local authorities, Scottish Government have agreed to pay for the remand places up until the end of this current financial year, so that's end of March 2025. And as part of our budget processing over the next few months, we'll be considering the longer term kind of funding for those remand placements. That doesn't include securely transporting children at the moment. And again, we'll be having further discussions about the ongoing costs for those. And I know there are ongoing kind of concerns around the availability of secure transportation, for example. And we have an arrangement with GOAMI for sentenced children, and we're looking into that contract as well to see what more can be done around the remand children. So those discussions are ongoing. The other point I just wanted to make before we move on is around the wider kind of care agenda, I suppose. And in particular, we commissioned Children and Young People Centre for Justice to undertake a project for us over the last year and a half to look at the future of secure care. And inevitably, those discussions obviously go wider than secure. And it's about thinking about the wider kind of care agenda. And we expect that report to be published in September, at which point the Scottish Government will, along with key partners, discuss the calls for action within those documents. So I think that's me for now, but I'll hand over to Debbie, who will then speak about the kind of practice implications.
Thanks, Liz. Okay, so I suppose just to kind of at the outset be clarifying, as I think Ranald has already done, this is building on existing practice, okay? This isn't starting from scratch. People will already have 16, 17-year-olds who are remanded or sentenced to secure care. People already have experience of that, so it isn't brand new. But the key changes are that all remanded or sentenced children who need to be deprived of their liberty will now be placed in secure care, not young offenders institutions. Scottish Government's roles will now and responsibilities will now apply in terms of funding remand places, as Liz has just mentioned, and for all children who are sentenced, with the exception being those who are placed into the care of the local authority. And all children who are remanded or sentenced will now need to be treated as if they are looked after children. So they are the most fundamental changes, and if that's the only bit that you take away from today, that's the most important part. However, we have been asked a little bit about practice implications here, so we thought it would be quite helpful just to take a child's journey and look at the roles and responsibilities. This is obviously wider than just the remand or sentence, but I think there's merit in that. And what I would say is there's a lot more information on roles and responsibilities in the briefing paper that has been published. Okay, so if we think about the first stage, then a child is appearing in court. The local authority should be notified that the child is appearing at court. There is a range of ways in which that is done, be that through police, be that through, Sheriff Clark, for example, be that through court-based social work. So local authorities should be aware that a child is appearing in court. But I think something for areas to think about in these sort of prompt questions are to try and help you guys take something away from today, to be thinking about not just the knowledge and information that's shared, but what does this mean for us? And these might be some of the questions that can help you in thinking that through. So is notification already happening? Is it consistently happening? Who's involved in that notification, and how, if that information is just being shared with just the social work in your area, how's that then going to be communicated with children and family staff, for example? So child appears at court. If the child's potentially at risk of being remanded or sentenced, the sentence part, the child shouldn't be suddenly becoming known at the point of sentence. Usually it wouldn't be known before that, although the remand part is probably the potential where children might be unknown, or maybe a bit more urgency of the response there. If the child's at risk of being remanded or sentenced, the local authority should be thinking about alternatives, and that could include electronic monitoring, for example, supervised bail, for example. And I think it's quite important here just to highlight the bail and release legislation, which will amend the circumstances in which bail can be refused, and will also require the court to state and record their reasons for their bail decision. So I think there's something really important there about thinking about how are partners informing the court of those considerations, and how are they communicating that. And at this stage, people should probably be thinking about bed and secure transport availability, although we'll cover the roles and responsibilities in a wee second. So some of the questions people might want to be thinking through in their agency or locally is about what alternatives to deprivation do we have? How can they be engaged at short notice? What are does our secure care policy or procedure already include children placed through a criminal justice route? What are the practical arrangements in that situation, and how are our roles and responsibilities fulfilled? And then when the child is in court or at any court appearance, the child should be supported before, during and after court. And that's a mainstay of the whole system approach. How that's done varies locally, but there are clear parameters about what support should be provided to children before, during and after, albeit that should always be tailored and rooted and based on children's needs. So some of the questions people might want to think about is, how is court support being provided? Who is involved in that? What information do they need on the changes of the Act? And how will we make sure court support is consistently available? Moving on then, so once the child's appeared at court, if there's a risk that the child is going, or when you know a child's going to court, In terms of remand, the remand responsibilities will remain with the local authority. The local authority will be responsible for arranging the placement, arranging transport, and any reviews of placement, albeit that Scottish Ministers, the Scottish Government, will be funding the remand placement itself. There's obviously, for remand, there's specific roles and responsibilities for chief social work officers and head of unit as set out in the secure care regulations. And they really need to be, I suppose, thought about what are our existing processes for that, who's involved, how are those roles and responsibilities understood and fulfilled. And I think that's just an important one to be thinking about. For some areas, you know, this will already be being done as bread and butter for most areas, but it's just thinking about if we've got children who now will be remanded to secure care who weren't previously, what do we need to think about? Then when we think about a child's admission to secure care, the secure care pathways and standards really clearly outline the information, support that children should receive, and who really should be part of that child's physical journey, I suppose, to secure care. So really important to think about that preparation, that support for the child and the family, but also the information provision. So how is information shared from the local social work department with the secure care centre? You guys will already be doing this when you're organising secure placements, but really making sure that those the information is available to inform planning, crisis management, risk management planning, for example, for the secure care centre. So really important to think about, this is all rooted in the secure care pathways and standards. What are we doing to implement them? Who's involved in providing this support and information? And then if we think about a child has been, pled or found guilty at court, then we're into a justice social work report being completed. I suppose something just to think about in respect to that is that as much as the child will be able to be sentenced to be deprived of their liberty, that will be in secure care, and also wanting to think about the Scottish Sentencing Council guidelines and how they're used as part of that. And then this I suppose fact of when the child's sentenced, the Scottish Government responsibilities for the placement arrangements, for transport and for reviews all sort of kick in. So some of the prompt questions that folks might want to think about is who completes the Justice Social Work report, what support do staff need in terms of this, but also what is the interface between Scottish Government reviews and plannings and processes and those of the local authority, particularly given that for all of these children, the local authority will have a clear role in that these children will be treated as if they were looked after children. And then finally, thinking about the post-admission meeting, so information should be shared at that time. Those meetings will normally take place within 72 hours, is a real opportunity to share information, to think about the plans and arrangements for that child, and the assessment process as well. So there's a minimum requirement set out in terms of the review processes, but also Chief Social Work Officer reviews, where relevant, Scottish Government reviews, but fundamentally looked after children reviews for all of these children. So some of the things people want to think about is who's responsible, are these children already part of looked after children procedures, and how can meetings be coordinated, planning processes be coordinated as far as possible, obviously utilising the child's plans. Then thinking about the support that's provided to a child throughout their stay in secure care, and also planning for their return to the community. And obviously we know there's a lot of work being done around about that, but also the Care Inspectorate review of the secure care pathways and standards highlighted still some of the areas that were really challenging for children in terms of the support that was provided and in terms of their preparation for returning to the community. But also just thinking there about what post-sentence support and entitlements to these children have. So thinking about who will be providing this support, what support do those individuals or teams who are providing the support require, and also in terms of aftercare entitlements for these children who might not have previously had them, albeit many of the children who are in YOIs have care experience and may well already have aftercare entitlements. And then finally, we want to be thinking about our evaluation and monitoring. How are we going to know what's working and what the challenges are locally, and how can they be addressed, but also how can we maintain a handle on what's happening nationally and what's working or not working. And just on these implications, so there's a lot in the briefing paper, but there's also the child's journey and our online resources at CYCJ that we will be looking to update in due course. So that is the substantive kind of content that we intended to provide today. We really want to give people a space for Q&As. So we'll just, Ranald, well, just to hand that over to yourself just to raise some of the questions.
Yeah, great. Thanks very much, Debbie and Liz, for that. That was really, really helpful. So, yeah, so we've got a few questions already. Janine has asked a range of questions, so I'm not sure if Liz and Debbie can read them. So, yes, question about just, I suppose, in the mechanics of the paying for secure remands, who will be funding secure transport, presumably for children that are on remand. What's the guidance if the secure estate doesn't have capacity or refuse to care for a child due to the level of risk? And then Janine also making the point about currently accessing secure transport, which can be a challenge, and whether there's going to be guidance about using maybe alternative methods of transport where that's needed, and how we're going to respond to just the overall increase in demand that there will be on secure transport. So a number of kind of issues there, but some of which have been maybe touched on already. So Liz, do you want to just...
Yeah, that's fine, Ronald. Yeah, happy to answer this. Thanks, Janine. So the local authority being reimbursed and the process, I suppose, for Scottish Government paying for remand placements is still to be formalised. The decision was only taken kind of last week or week before, so all of that work still needs to be kind of bottomed out. But we'll be doing that as kind of soon as possible. So I think the sensible approach would be that secure providers invoice Scottish Government once a child goes into secure on remand, but we just need to kind of establish the exact process. Secure transport, obviously I've mentioned that at the moment that isn't going to be funded by Scottish Government, but it's something we will consider, or we are considering, as part of our budget process. So that cost will remain with the local authorities. Now, I know, obviously, that's, as I mentioned before, that's a long-standing issue around kind of secure transport. And we do have provisions within the Act, which haven't been brought in yet, which are around standards for secure transport, which is a small kind of part of that, I suppose. But it's more work does definitely need to be done around kind of secure transport. And I think the point around the cost of transport, the availability of transport, who is responsible, all those kind of issues are still ongoing. They're not resolved through this Act, and they're certainly not resolved with the under 18s and YOI aspect. Sorry, so that's areas that we do need to kind of have a look at and continue with. So your point around guidance as well to local authorities around transporting children. Obviously, that's something we can think about as part of the standards process, but that's not something we've developed or developing at this point in time. You've made the point, Janine, around kind of 1 week's notice for having this session, and I appreciate that. And, you know, unfortunately, we're having to work at pace with this, and having these sessions any earlier, we wouldn't have been able to give much detail because obviously of the provisions and commencement regs being laid in Parliament only last week. So there's only so much we can kind of say until things actually commence. But, you know, lots of our key partners have been engaged in discussions, and we've been involving Social Work Scotland. And I was on a call just before this with Chief Social Work Advisors as officers as well. So there has been, you know, engagement already leading up to this. I think that answers most of the questions you've given to me.
Yes. And Mark White had made a related point, I suppose, just raising concerns about using GOA for secure. Yeah,
no, and obviously the GOA contract is a contract that we have, and it's an offshoot of the Scottish Prison Service kind of contract. So that is for sentenced children. They are in separate vehicles. It's child-friendly vehicles. So we have a slightly separate kind of contract with GOAMI for those children. So it is very much kind of child-friendly welfare of the children at the heart. But I appreciate the main kind of GOAMI contract obviously is wider than that. So I just wanted to make that point clear, that it is a child-friendly kind of contract that we have in place for those children.
Mm-hmm. Yeah. And again, the issue of secure transport obviously is quite live for folks. So yeah, Lorna's just asking what do we mean when we say that, the government is looking at this? But so I suppose it is built into the Act, isn't it, in terms of a year to come up with a plan to secure transport
standards. Yeah, and I suppose just to say that obviously it's a collective responsibility, and it's a partnership agreement that we need to kind of all come around the table to discuss secure transport. And I know those discussions have been kind of ongoing for a year or so, if not longer. And I know there was the group that COSLA set up to look at kind of the secure transport. And it wasn't standards they produced, but it was a kind of performer, I suppose, for which will help with the secure development of standards, which, as Randall said, will need to go out to kind of consultation and other discussions, and the timescales for that part of the Act, commencement of that part of the Act, haven't been agreed as yet.
Yeah. Great, thanks. So just going back up again, somebody, Nicole just raised the point which does come up quite often, just about the confused legislative landscape now that is being created here, where 16, 17-year-olds are children in one context and adults in the other. So I suppose just kind of quite rightly just raising that again as something which hopefully can be looked at, in due course, in terms of how does Scotland overall view and treat 16 and 17-year-olds. So I'm not sure if you want to comment on that at all, Liz, or...
Yeah, no, I mean, I think, was that Nicole's point? Sorry.
Yeah, that's right.
Up to age 25. Yeah, I mean, I think that's, we've got our youth justice vision, which we do kind of say kind of expands beyond the age of 18, and as does the whole system approach policy. But yeah, it's definitely one of those that we need to kind of have that discussion. It's justice colleagues as well within Scottish Government need to kind of be involved in those discussions as well.
I think it might just be worth saying, sorry, I can't see everyone on my screen, so it might just be worth jumping in that way as well, just to say that there's something about what is the impact on children's rights of the different definitions. So actually, in some points, having the definition of a child younger helps to give children more rights, and in other areas it doesn't. So I think there's something to be quite cautious around about that. But this is a theme that keeps coming up, particularly in terms of the interface between this Act, UNCRC, the mental health legislation, for example, housing legislation, adult support and protection legislation. And I think it would just be really important to recognise that even when this Act is fully commenced, it will only change certain definitions of a child, which I think is exactly the point that was being made there. But that it will, there will still need to be that kind of consideration of the needs of the child. What are the different options that are available? What can different pieces of legislation offer to the child to meet needs or address risks in particular situations? And what is the most appropriate vehicle for doing that? So just think it's important to recognise this has been raised frequently.
Yeah. Great, thanks. So Kath has helpfully kind of shone a light on just that thing we referred to earlier on about the two ways that a court can deal with a remand child. The kind of direct route where the court instructs the child to be detained at a specific secure centre, or the much less used alternative of putting them in the care of the local authority, who then put them in a place of safety. So, which is it's been in legislation all along, but has been a very underused option. In my time at Renfrewshire, we only used it once. It was very effective, I have to say. But yeah, so yeah, Cass just saying how aware are sheriffs of this, and I suppose by the same token, how aware are defence agents and kind of other key folk involved as well, social work, local authorities. What's the process for asking a sheriff to consider the option of that kind of lesser used option?
Yeah, so I'm happy to jump in there if that's helpful.
Great, yeah, thanks, Debbie.
So I suppose the part about the judiciary and defence agents, as Randall said, this is like 1995 Criminal Procedures Act. It's kind of 30 years down the track, so you would kind of hope people are aware of it. But if it's not, it does seem like it's not used that often in practice. What I'm wondering is, as part of this Act, this is another window of opportunity to reinforce some of those messages. And I think we're in a slightly different landscape now with the bail and release legislation, for example. So certainly that's one we can take back to, Scottish Courts and Tribunal Service and Judicial Institute and look at what's being provided and whether some further information on that is an option. I suppose just in terms of how can courts be made aware. So I suppose in the first instance, when you're really wanting the child to be remanded to the care of the local authority, for the local authority to decide where to place the child, it's how is that information communicated to the court. So be that what's used locally, court notes, social work be present, whatever else, and how that information can be made available at the point of that remand decision being made. But secondly, then, when a child is remanded to secure care directly, not to the care of the local authority, there is grounds for a bail review if there's additional information that can be made available to the court that wasn't the first time round, or if there's a change of circumstances. So that would be your other option. I appreciate that that's probably not an ideal option because you've got a child transitioning into secure to potentially transition out if that bail review did result in a change of decision. But it's very difficult to really, I suppose, preempt that in any way, but they could, bail review would be kind of your really only legislative route to do that. Yeah. Ranald, I'm not sure if there was anything else you would have added there.
I don't think so. Okay. And that's fine, thank you, yeah, cheers. And Nilufer also, asked a question about the responsibility for justice social work reports for under 18s being sentenced. So I guess we recognise that in different authorities that will lie with different teams and different responsibilities there. So some will be done by children and families, some by specialist youth justice social workers, and in some areas maybe by adult justice workers. So as long as, I guess the key thing there is that it's important that everybody's aware of what they need to be doing in terms of liaising with the Scottish Government prior to a young person being sentenced if custody is a possibility. With that,
sorry, Janine's point. I didn't speak about the if a secure centre refuses to take a child or hasn't got capacity. Sorry, Janine. That's another long-standing issue, isn't it, really? And we are well aware of times and cases where that has happened. So obviously the capacity, the Scottish Government funding of capacity building, the 16 beds, is to kind of help alleviate some of that. And obviously we'll only go a short way with some of that to allow capacity. But the ability for the secure centres to kind of the veto, I suppose, to refuse a child, it's still in place, and it will still need to be in place because obviously they have their matching process. The process at the moment is what we have done over the past however many years, is that, any concerns are kind of raised normally with ourselves, but with the secure providers, and a process is undertaken, an emergency process is undertaken to discuss that child and think about what alternative measures and resources can be put in place for that child. So those processes will still continue. We are drafting a memorandum of understanding between ourselves and secure providers around sentenced and remand children. And there's nothing to say that once that's agreed, that process couldn't be extended or looked at for all children. And that's something for COSA and Social Work Scotland to consider as well. And we have kind of mentioned that to them. So there are still some kind of concerns or issues around that. And obviously that MOU process isn't foolproof, but it's about the collective responsibility of all partners kind of to kind of really when an issue does arise like that those discussions take place. And obviously we will need to kind of reassess that as time goes on over the coming months, if there's still kind of big concerns around that. I don't know if that's maybe not completely answered your question, Janine, because it is a live issue and it's we have it's of concern.
Yeah. So Michael's saying, can I confirm the young people will be considered to be looked after? So yes, that is the case. They have the same kind of rights and entitlements there.
And Lorna's point
yes.
around the young person turning 18. So at the moment, the legislation which would see consideration of a child up to the age of 19 isn't in place. So that needs what's called affirmative regulation. So that's a lengthy process of parliamentary sign-off, an agreement and consultation process. So we'll start that process soon to consider that legislative kind of change. So at the moment, it means that anyone turning 18 will automatically be moved on their 18th birthday, as is currently the case.
Great. Okay, I think that's us got through all the questions that are there. So unless anybody jumps in the next few seconds, I think we'll probably draw things to a close. So, thanks very much to Debbie and to Liz for all their input today. And, hang on. Okay. Thanks, Colin. That's a nice positive message to end on. It's great. Kia Owen is from, okay. Thanks for that. So thanks, for your input today, and thanks for the questions. Clearly, this is an ongoing process of teasing out all those issues. So, if you go away from today and there's a question you wish you'd asked, please get in touch with CYCJ, and between us and the government, we'll do our best to respond. And like I say, we'll add all these additional questions onto the next version of the info sheet, which will be revised and then reissued after the second webinar has taken place. So this is really just part of a bigger process of engagement and supporting you guys in the field to be as ready as you can be, and to hopefully avoid any pitfalls as much as we can as well. So thanks for your time today. And like I say, this will be recorded and it will be published on the website as well. So if anything you've missed, or other colleagues want to see what was discussed today, then they'll be able to access that way as soon as possible as well. So thanks very much. Thanks to Debbie and Liz in particular, and have a good rest of the day. Thank you. Cheerio.
Thanks everyone. Bye.